Marriage under Hanafi law. There are three classes: irregular marriage, valid marriage, and void marriage. Marriage with a woman undergoing iddat is an irregular marriage. Suppose there are certain other examples of this irregular marriage. There are certain essentials of a valid marriage. The presence of witnesses is a necessity to constitute a valid marriage. When a nikah is solemnized, there should be present two male persons as witnesses, or one male and two females. So the witnesses are essential for the constitution of a valid marriage. But suppose the marriage is solemnized without witnesses. What is its effect? It is very simple that marriage in the absence of witnesses is irregular. When two witnesses are required and the witnesses are not available, then the marriage is irregular. Irregular means that it may be regularized later on. So there is another aspect, that if a person has 4 wives, under Hanafi law of marriage, a person may have as many as 4 wives. But if he enters into a marriage contract with a 5th one, then what happens? What about the marriage? The answer is marriage is irregular. If a person enters into a 5th wife having as many as 4 wives, then the marriage with the 5th wife is irregular. There is another example of the irregular marriage, that is a difference of religion. Marriage with a woman who is a worshipper is irregular. It is not void. So if a man enters into a marriage contract with a worshipper, then the marriage is irregular. There is another example of an irregular marriage, and that is called unlawful conjunction, meaning thereby that a man may have 2 sisters at one and the same time. If he is having a sister and he enters into marriage contract with the second sister, then the marriage is irregular. The simple formula of adjudging the unlawful conjunction is that if both are intermarried, being as one male and the other female, they cannot enter into a marriage contract. Then this is an unlawful conjunction. Suppose there are 2 sisters. If one of them is brother and other is sister, then they cannot intermarry. So if both are of this relation, that if one of them, if he is a male, they cannot enter into a marriage contract, this marriage is called unlawful conjunction. So the marriage with 2 sisters is an irregular marriage. What is the effect of irregular marriage? If a man enters into a marriage contract which is an irregular marriage, then what is its effect? An irregular marriage may be terminated by either party. In case of a regular marriage, a man has a right to divorce the wife. It is unfettered powers. But in case of irregular marriage, both parties have the similar rights, meaning thereby an irregular marriage may be terminated by either of the parties before or after consummation by words showing an intention to separate. So the intention is very important in cases of irregular marriage when it is going to be dissolved. Both parties have the similar right to dissolve the marriage with the intention of dissolving it, or by the words of mouth that they are going to separate themselves. So there are certain circumstances when they enter into an irregular marriage, but later on it is regularized. Then when it is regularized, then it becomes a valid marriage. So the wife is entitled to dower in cases of irregular marriage. It is the effect of irregular marriage that the wife is entitled to dower. It may be proper or it may be specified, whichever is less. If there is a proper dower or there is a specified dower, if the proper dower is less, that shall be paid. If the specified dower is less, then that shall be paid. So the effect of an irregular marriage is that the wife is entitled to the dower, proper or specified, whichever is less. The third one is that when they are separated, she is bound to perform iddat. In case of irregular marriage, the wife is bound to perform iddat, meaning thereby that 3 courses are to be observed. The effect of irregular marriage is that the children are legitimate. They are entitled to inherit the property of their father. So when the father enters into an irregular marriage, the children are born, those children are legitimate and entitled to inherit the property of father. But the question is whether the wife has a right of inheritance. The answer is that they don't have mutual right of inheritance. Wife and husband both are not entitled to the inheritance. Now, these are the incidents of irregular marriage, that it gives effect to certain things. The children are legitimate, the marriage is dissolved with mutual consent, both have the same rights, but they are not mutually entitled to inherit each other. So there are certain marriages which are void. So what are the void marriages? Marriage with a woman prohibited by reason of consanguinity, by affinity, or fosterage. Consanguinity means when the marriage is on account of consanguinity, the marriage is void. Marriage with his mother, for example, marriage with his mother, marriage with grandmother, how low soever, marriage with grandmother, how high soever, marriage with sister, whether full sister, consanguine sister, or uterine sister, the marriage is void on account of consanguinity. Marriage with niece, marriage with great niece, marriage with aunt, marriage with great aunt. So these are examples of void marriage. So a man cannot enter into a valid marriage contract with all those who are the persons having the relations which I have enumerated before you. So the marriage with an affinity is also void, meaning thereby wife's mother or wife's grandmother, wife's daughter or granddaughter, wife of his father, that is void marriage, paternal grandfather, marriage with wife of his son, grandson, daughter, howsoever. It is to be remembered that marriage with the wife's daughter or granddaughter is prohibited only if the marriage with his wife was consummated. So if the marriage with the wife is consummated, then in that case the marriage shall be void for affinity. Then there are examples of marriage with fosterage. So those are also void. But there are certain exceptions to the marriages of fosterage. In those sisters, foster mother, foster sister mother, foster son's mother, foster's mother, no marriage at all. The void marriage is no marriage at all. So all children, all offsprings, all issues coming out from this marriage are illegitimate. The effect of void marriage is that the children are illegitimate. They are not entitled to inherit. The wife is not a wife in the real sense of the term, so she has got no right at all, and the husband has not obliged to perform anything in favor of wife. So when the marriage is void, it is void for all purposes, and the persons are not entitled to mutually inherit the property. So so far as the void marriage is concerned, it is no marriage at all. It is not supposed to be a marriage in the eye of law. So far as the valid marriage is concerned, that is a social contract. That is a valid contract, performed in accordance with injunctions provided by Hanafi law of marriage. So the effect of marriage is that they are bound to perform marital obligations. The husband has the obligations, the wife has the obligations, and the effect of marriage is that the wife is entitled to dower, wife is entitled to maintenance, wife is entitled to residence, and there are some authorities which use the word chaaiyé pandan. The wives are entitled to chaaiyé pandan. So they are entitled to that type of maintenance that may be called as the pocket money. They are also entitled to that. So there are marital obligations mutually agreed between the parties and which are prescribed by the law. And the children are legitimate. They will inherit from father as well as from mother. So these are the classes of marriage: valid marriage, irregular marriage, and void marriage. And they have their own effect on the rights of the parties. Now the next question is how the marriage is proved. There is a direct proof of marriage, the presence of witnesses, and in the law of the land there is a nikah nama entered into between the parties nowadays. So that nikah nama is a direct proof of a marriage. It contains all the terms and conditions which have been entered into between the parties at the time of solemnization of nikah. So it depicts, and it is a good evidence of the existence of a married nikah. So there are certain other direct proofs of marriage. But if direct proof is not available, then what happens? So the law recognizes that if the direct proof is not available, then you are entitled to prove the marriage through presumptive proof. So what are the presumptive proofs? I am going to state before you. Marriage will be presumed in the absence of direct proof from prolonged and continual cohabitation as husband and wife. So the long cohabitation is a presumptive proof of a valid marriage. Number 2, the fact of the acknowledgement by the man of the paternity of the child born to the woman. But this part of presumption is not always valid, because there should be reason prescribed as by the law of the acknowledgement. So the acknowledgement, if the acknowledgement is proved in accordance with the law, then the acknowledgement shall be a presumption of marriage. But if the acknowledgement of the paternity is not in accordance with the injunctions of Islam and the rules prescribed by the law, then that is no acknowledgement, and that is not presumptive proof of marriage. The fact of the acknowledgement by the man or the woman as his wife. If a man accepts a lady as his wife, it may be presumed that he several times or one time admitted her to be his wife. So there should be certain circumstances which should be sufficient to accept this acknowledgement. Suppose a man says that B is my wife, but B had entered into a valid marriage contract with another person. Then his acknowledgement is immaterial. So the acknowledgement becomes material in accordance with the circumstances of the case. So all those circumstances should be available, which may enable us to infer that the acknowledgement is valid. So the acknowledgement by the husband as his wife and the wife as a husband is a sufficient presumptive proof of marriage. So that's all so far as the Hanafi law of marriage is concerned.